Good morning, everyone. We see people are still coming into the room, but I propose that we start because we only have a 1-hour session this morning on a very important topic, effective remediation and sustained compliance in the world of work. My name is Geeta Rollins, and I'm the head of the Multinational Enterprises and Responsible Business Conduct Unit in the Sustainable Enterprises Department in ILO headquarters in Geneva. So a very warm welcome to all of you, and we thank you for your interest in this topic. So this morning's session, will focus on effective remediation and sustained compliance in the world of work. So dealing with what access to effective remedy for workers looks like and what more is needed for sustained compliance with national law. Many ILO standards, conventions and recommendations include provisions on what the state should do to provide access to remedy for workers, both through judicial and non-judicial mechanisms. The ILO also has a specific recommendation on the examination of grievances within an enterprise with a view to their settlement. Access to remedy and examination of grievances is also included in the ILO's Instrument on Responsible Business Conduct, in the ILO M&E Declaration, with recommendations that are both addressed to governments and to enterprises, as well as to the social partners, employers, and workers' organizations. However, we observe a rise in individual and collective labor disputes globally, including in the Asia-Pacific region. Today's labor markets indeed are undergoing major changes due to various factors, and we will be entering into a number of those factors with the panelists. But let me just highlight a few of them. The introduction of new business models, shifts in supply chains, geopolitical tensions, impacts on employment by increased digitalization and artificial intelligence, and by transitions towards environmentally friendly production methods. All of these have led to major disruptions, or can lead to major disruptions in labor markets, and also put out to the forefront the need for robust and effective mechanisms for dispute resolution that supports sound industrial relations and promote effective access to remedy for workers individually and collectively. In December 2023, the ILO published a report that reviews how labor disputes are defined across jurisdictions, their legal and material scope, the mandate and composition of dispute resolution mechanisms, as well as procedural matters that govern dispute handling in the world of work. And in February 2025, the ILO will convene an expert meeting on access to labor justice to examine what should be done more. So just to say that this is very high on the agenda from governments, employers, and workers alike. For this morning, we have a panel with 4 excellent panelists from different countries in the Asia-Pacific region. And in 2 rounds of questions, the panelists will share their perspectives on, first of all, what are some of the challenges related to access to remedy in the world of work? And secondly, what effective mechanisms look like for individual and collective labor-related disputes. They will also share examples of the collaboration between governments, employers, and trade unions in the design and administration of grievance mechanisms, and finally discuss the role of labor inspectorate in improving compliance with national laws and in facilitating remediation, including through better collaboration between labor inspectorates and the judiciary to adjudicate disputes. And then after the 2 rounds of questions with the panelists, we will open the floor for questions with all of you participants in the room. So now let me briefly introduce our 4 panelists of this morning's session. So first of all, we have Mr. In Chul Kim, standing member of the National Labor Relations Commission, which is a government agency affiliated with the Ministry of Employment and Labor of the Republic of Korea. Very warm welcome to you.
Thank you.
Then to my left also I have Mrs. Cecilia Tree Sulistiawati of the Employers Association of Indonesia, APindo. Very well, welcome to you as well. To my right, Mr. Visna Nuan, Country Manager of UNAID Abroad, AFIDA, Cambodia, from Cambodia. And then we have Mrs. Valkyrie Hansen, Regional Coordinator for Decent Work in Supply Chains in the ILO Regional Office here, Asia Pacific. So very well welcome to all of the panelists. So we will dive immediately into the first round of questions, which is indeed dealing with some of the challenges to ensure effective remediation and access to labor justice in various countries in the Asia-Pacific region. So let me start with you, Mr. Kim. What are your observations in relation to the challenges?
Good morning, nice to meet you all. Thank you for giving me the floor. Despite improvements in remedy systems, challenges remain in ensuring effective remediation and access to labor justice as various forms of employment, including platform workers on freelancers, are emerging. On the other hand, AI and robots will replace the human jobs. Despite have become increasingly complex, extending beyond the typical issues like unfair dismissal to include cases of workplace harassment, sexual harassment, and gender discrimination. The Korean Labor Relations Commission, LRC, faces limitations with the current system, especially with the rapid increase in cases being filed. These evolving challenges require new approaches, as traditional methods are no longer sufficient. To address these challenges, the LRC is implementing diverse measures to resolve labor disputes and strengthen workers' rights to remedy. The LRC ensures that everyone is satisfied based on the voluntary participation of the disputing parties rather than judging in uniform manners. As part of this effort, LRC explores ways to actively utilize alternative dispute resolution, ADR, including reconciliation and mediation, alongside traditional education. The LRC now holds preliminary reconciliation meetings before making decisions on remedy applications. Public interest committee members facilitate this process by listening to the positions of each party and work towards resolving disputes through reconciliation, fostering mutual communication, and proposing realistic solutions. This approach has seen an increase in the reconciliation rate from 26.8% in 2019 to 30.5% in 2023, indicating its growing effectiveness. To further strengthen dispute resolution capabilities, the LRC provides extensive training to public interest members, investigators, and even private experts, such as conflict management and reconciliation skills. Another challenge is ensuring that those seeking remedies can easily access the system. To address this, the LRC is developing a digital platform, Digital LRC. The system will enable parties from afar to participate via video conferencing and assist in easily searching related legal precedents and ruling from the LRC. Recognizing the global nature of these challenges, the LRC is actively engaging with overseas dispute resolution agencies. An international conference is scheduled between September 26 to 27, tomorrow, in Seoul, South Korea, bringing together key figures such as the General Counsel of the U.S. National Labor Relations Board and the Chairman of the Japanese Central Labor Relations Commission. The conference will focus on employment and labor disputes and countermeasures in the digital age to reinforce global cooperation in resolving labor disputes, particularly within the Asia-Pacific region. Thank you.
Thank you very much, Mr. Kim, for sharing, first of all, some of the challenges and so the need also to look for innovative ways of dealing with labor disputes. This is very promising, and I'm sure in the second part, when we look at the new opportunities, what presents as new opportunities for dealing with these new challenges when it comes to access to remedy, you can be further elaborating on some of these innovative approaches, including of alternative dispute settlement. So I would like to hand over to Indonesia. Cecilia, can you share some of the challenges in relation to Indonesia and access to remedy?
Good morning, Sawadika. To give a context, as I work from for the multinational company perspective, so we work with many vendor and suppliers. So the first challenges is the supply chain complexity. Ensuring diverse and significant number of suppliers to comply to human rights standard requires continuous monitoring, assessment, capacity building. And second challenge, actually the culture and legal difference. Operating in diverse region with varying cultural norms and local practices can be complicated in establishing standard policies. For multinational company, the challenge is to set the human rights standard to all business operating in many diverse regions, considering the culture and legal differences. In some cases, there are developing countries where the regulation is also still developing and local practice may be different with the Western countries. The other challenges is the grievance mechanism. Establishing effective mechanisms that are accessible and trusted by all employees and stakeholders. Speak up culture also is not common for ASEAN in this case. There are cases when the people still do not trust the grievance mechanism as it may impact to individual employment. Employee might fear negative consequences for speaking up, such as being labeled as a troublemaker or facing career setback. That's the example. Another thing about the gender norms and discrimination. In some cases, sometimes women are treated differently compared to men, especially for employment opportunities. This is indeed significant challenges considering majority belief in people in Indonesia, where women maybe better stay at home. That's for the example. So I stop here. Thank you.
Thank you very much, Cecilia, to share all the perspective also of a multinational enterprise dealing with different legal and cultural context. And as you pointed out, even with the grievance mechanisms, even if you have a grievance mechanism, it's very important that there is trust in this mechanism and that workers do not have fear for any kind of reprisal in putting forward some of their grievances, and also highlighting the specific challenge for women when it comes to using these mechanisms at the enterprise level. So going now to Cambodia and of course to the workers' perspective, Vesna, can you share some of the challenges that you observe in Cambodia, but also more broadly when it comes to this access to remedy for workers at the different levels, I would say, from state mechanisms and also enterprise level grievances? Over to you.
Yes, thank you. Yeah. Well, I mean, yeah, so a good opportunity to share experience that we got from Cambodia. As you know, is a country which very much, you know, like experiencing the export sectors, you know, to the developed world. You know, of course, the access to remedies and so the labor justice is so important in the environment. I would say, you know, the key challenges in regard to access, in particular to the remedy, I think on the main there are three from my side. From the worker experience, I think one is the nature of the employment relation. So it's, a country which employment is provided on the basis of short-term contract, but also in the enterprises which are engaged as a subcontractors, so it's not the main production form or certain, but rather a precarious, a kind of short-term labor relation engagement, and that's provide a risk of uncertainty over the right itself, like what kind of rights that a worker would have. So many of the workers would be employed and then just know how much they're going to be paid, monthly. So instead of getting a comprehensive understanding, but also monetary and non-monetary rights provision. So, but also a enforcement mechanism itself, right? Like given the precarious nature of the employment relation, it also what kind of institution, in this case at the enterprise level, likewise at the national level, like a kind of weak labor governance structure, I think, which not only in Cambodia but also in the developing countries, so it's like labor governance structure, which is built strongly enough to cope with grievances brought up from the local level. So, and the second challenge is, I think, which is fundamental in itself, is the issue of freedom of association. So, it's a kind of lack of cooperative approach. One is on the issues, but second is on the mechanism itself. So of course, linked to what Cecilia also mentioned about the complexity of the supply chain. So basically, global brands would source from country like Cambodia through very often intermediary as well. And then, and very often, intermediaries may not be familiar with industrial relation, a typical fair industrial relation structure, so it's the ability, the interest to engage with worker representations, so that is a kind of a lack of meaningful consultation. So basically recognizing the key role of the workers and employer actors, but also engagement on the issue as well to address promptly. And then I think, I think if we look into UN governing principle on business and human rights, you would see one of the criteria for effective remedy, it would be on the engagement, like giving the opportunity to worker representative to co-design the mechanism. So which I think very often is an absence at the particularly in supply chain. And I think lastly, I would kind of link to what Cecilia mentioned, the complexity of the supply chain itself. Which is like there's kind of external determining factors from the sourcing company. In this case, I would refer to purchasing practice as a key, because of like what you call inappropriate purchasing practice would kind of lead to the issue we're talking about. Yes, like engagement with worker organizations, representation. Very often if you don't have a good purchasing practice, it lead up to risks that we are talking about. Like overtime, and other kind of short-termism in industrial relation, employee relation we're talking about.
Thank you very much, Vesna, for sharing these challenges. And you mentioned also, in the lack of enforcement mechanisms, weak labor governance structure. And I think that is a very good introduction also, Valkyrie, to some of the work, of course, in relation to labor inspection, labor administration. So what do you observe as challenges here in the region in relation to these institutions?
Yeah, thanks, Yukita. So I'm here representing our labor inspection, labor administration branch, which is work that I was doing prior to my current role. So labor inspection, really, its primary goal is labor law compliance, right? And it does that through two key mechanisms. One is preventative assistance to provide sort of advice and guidance to employers to comply. And a second is enforcement. What you will notice about those two sort of categories is giving remedy to workers is not necessarily part of their function. Labor inspectors are not conciliators. Many labor inspectors can identify a violation, suggest a sanction, or even penalize, but cannot necessarily provide a worker back wages or compensation for an injury or accident or disease or other types of issues. So that is one of like our primary challenges when talking about this through labor inspection lens. I think the more important component here when we're talking about labor law compliance is simply the vastness of the challenge for labor inspectorates. If you imagine sort of a very large circle that represents the full jurisdiction of the labor inspectorate, right? All of the workers, all of the employers, all of the work sites that are subject to their jurisdiction, right? And then you think about the resources that are available to labor inspectors, it's like a tiny red dot, right? And of course, the main issue that we find with that is that most labor inspectors do not have the capacity to target, right? They do not have sufficient data or sufficient information to make sure that they're spending their very limited resources on the work sites that most need their attention. This is exacerbated by a number of things. One, obviously, is low union density. Unions obviously educate their workers. They're obviously sort of the first line of defense in identifying sort of issues, and they can bring those to the fore in an effective manner. When you don't have that, right, we find that complaints are a poor indicator of whether or not there's compliance, right? Workers that know how to complain do. Workers that most need to complain don't know how to do that. So we have that first issue in relation to targeting. The second issue beyond that is labor inspectorates do not have sufficient tools, right? As I was saying, labor inspectorates can enforce. Many don't have the power to sanction. Many have the power to sanction, but such a small amount that it's not really going to make a huge impact. And many, again, don't have the power to suggest a remedy for a worker or to make sure that that worker is made whole again for that particular violation. And then another thing that we find is labor inspectors don't necessarily have a mechanism, right, to get that learning, right, from having gone and done that inspection, identify that violation, instructed the employer on how now to come into compliance. How do you get that learning now to other work sites in that same supply chain, in that same sector, or in that same region? Those are some of the challenges that we find when we're talking about labor law compliance. And I guess in the next question, I will come back to some of the solutions.
Thank you very much, Valkyrie, for really highlighting some of the challenges in relation to enforcement, as you say, and compliance, which of course is a critical element when it comes to access to remedy, because that's the other side, access to remedy, and of course, compliance with national laws, which is a requirement also for all enterprises, is to comply with national law. Now moving again, I mean, now that we've discussed some of these challenges, of course, we also want to see some of the solutions or some of the innovative approaches that we have been identifying or trying out, whether it's from government, from employer side, unions, and also some of the work that ILO has been doing in supporting our constituents in the member states. So back to Mr. Kim. You already mentioned, in your, dealing with some of the challenges, you already mentioned, for example, alternative dispute settlement, conciliation, mediation. You also were mentioning engaging with overseas dispute resolution mechanisms and so on. So could you elaborate a little bit on these innovative solutions that you are working on as part of the National Labor Relations Commission in Korea?
Thank you, Gita. To address your question, I will explain the mechanisms within the Korea remedy system of the Korean National Labor Relations Commission, LRC. The LRC, a neutral and independent quasi-judicial administrative agency, has been instrumental in stabilizing and developing labor relations. It protects workers' rights from unfair dismissal and employment discrimination through education, and quickly and fairly resolve disputes between labor unions and employers through mediation. Initially, the LRC's primary focus was on mediating collective labor disputes. However, as labor relations became more complex, the LRC expanded its scope to address a broader range of labor issues, making it more comprehensive and effective institution for resolving disputes. The Korean government, in designing the LRC's remediation systems, prioritized 4 key values: fairness, reliability, speed, and accessibility. These values are embedded in the LRC's operations and have been critical in making each remediation mechanisms highly effective. First, fairness. The LRC is composed of tripartite commissioners representing employees, employers, and public interest. This tripartite structure ensures that decisions are balanced and fair. Members of the LRC are protected by law and are required strict conduct to handle cases fairly. Second value is reliability. The LRC division or committee consists of experts from various fields, including professors, judges, lawyers, and high-ranking public officials. This expertise ensures that cases are handled with a high level of professionalism and reliability. Unlike the court system, which really relies solely on the material submitted by the parties involved, the LRC operates on the ex officio principle. This allows the LRC to investigate facts, collect evidence, and base its judgment on a broader range of information. As a result, each decisions are more thorough and reliable, while workers are relieved of the burden of collecting proof of their own. Third, speed. Prompt relief is critical in labor disputes, and the NRC delivers this by making decisions on remedy application within 60 days. The average processing time is even faster at 55 days, which is 5 times faster than the average litigation case in court. Lastly, accessibility. It is free to file a case with the LRC, making it accessible to all workers. In addition, for workers with monthly average wages of less than $2,200 US, the LRC provides supports free legal assistance from lawyer or certified labor attorney. This support significantly enhances access to remediation for vulnerable workers. As a result, 21,000 cases were filed with the LRC last year, and this year the number is expected to reach 25,000 cases. And ADR, about ADR, the ADR, such as mediation, arbitration, and conciliation to support the voluntary dispute resolution of the parties. ADR allows disputes to be resolved by mediation instead of strikes and by conciliation instead of education. The LRC plans to introduce a system to nurture and certify ADR experts, so-called peacemakers. So there are culture of dispute resolution based on a dialogue and negotiation can take root in the industrial field. Thank you.
Well, thank you very much for sharing this and just highlighting again what are some of the elements to actually have a trustworthy mechanism. And I think I just want to repeat some of them. Fairness, reliability, speed, enhanced access. These are a number of the elements that you clearly highlighted. And I must say, mediation, conciliation, adjudication, certification of these mechanisms. And I must say, I'm very impressed with you dealing with 21,000 cases. This is enormous for an institution to deal with. And if indeed you are able to do this within the limit of 60 days, as you highlight, this is a very important mechanism. So I think it could be good to even share a bit more what these cases are all about. You already mentioned In the first one, unfair dismissals, I think that is definitely a number of the cases. Gender discrimination you mentioned, but are there other specific topics that you see coming out in those cases?
So there are a few cases, for example, for the platform workers in South Korea right now, there are also caught a lot of bullying and unfair cases within the workspace. So the LRC is working to increase the accessing methods between the workers and the employers.
Thank you all very much. So over again to Cecilia. So what do you see as some of the innovative approaches to enhance access to remedy and how employers are actually participating in a number of the mechanisms within Indonesia?
I don't know whether this is innovative, but if I may share our practice. So the first critical things for implementing human rights is to have the commitment of the management from the top. And then the commitment and then complemented by other companies' policy, such as our code of conduct, and then responsible sourcing principle, agriculture labor practices code, marketing code, etc. And after having human rights commitment and set of relevant supporting policies, company then needs to conduct the human rights due diligence across its value chain. This involves a process to identify, prevent, mitigate, and account for how the company then address its impact on human rights. And the saliency mapping is an example of human rights due diligence. It serves to identify and assess salient risks to human rights across business operation and value chain from the perspective of the right holders. The analysis assess risk against the right within the UN Declaration of Human Rights and based on the UNGP's indicators such as scale, remediability, and likelihood of negative impact. And of course, to have the grievance mechanism. This is fundamental that companies should establish. So we have a very robust approach, an effective grievance mechanism for individual and communities who may have adversely impacted by the company operation. We need also maintain a clear speak up policy and then run regular training to encourage employee to speak up. This is become the regular training. And then maintain contact for reporting. The individual supervisor, department head, or affiliate or function leadership. And then we have compliance e-contact. We also have the global compliance confidential email address and compliance helpline online or by telephone, which is the third-party operated reporting channel available 24 hours a day, 7 days a week in all languages spoken by company. So individual may use the compliance helpline anonymously, subject to local laws and regulation, of course. And the last thing that's very important, also the transparency and reporting. The report will show the commitment of the company, our company, to public about the implementing the human rights.
Thank you, Cecilia, for sharing what your company is doing in terms of its commitment to human rights, including through policies, human rights due diligence mechanism, as you say, mapping of the salient risks to right holders, which is an important element of what you are doing, and then setting up the grievance mechanism, plus training of workers to speak out. So can you share with us a little bit the experience within your company of how this is being used by the workers and the impact of the kind of grievances that you see in then changing some of the policies of the companies? Do you see this happening as well? Or is it too early to say?
It's already happening. So, oh, sorry. Yeah. So, start with the, of course, at the beginning, it's very difficult to ask employee to speak up with some to fear the negative impact of course. But we regularly have conduct a training session, and we introduce this to all employee, and even this come from our top management. And also the commitment it show when there is evidence that the employee call the hotline. So we follow up all the complaint, all the concern, and then we share. But of course, this is confidential. But yeah, we share that there is the report, and we in progress to follow up that report. Yes.
So I think, Vesna, this is a good, transition to you as well, because workers speaking up about some of the violations that are happening, how difficult is it? And, then what are some of the innovative approaches, and how do you really build trust into the system so that workers can find effective remedy?
Yes, thank you. Yeah, I think I'm just in the time that I have. So basically, I think I come back to the point. I think as a solution, potential solution, it would be the opportunity provided to the worker representative to co-design the mechanism to provide remedy in the case of violation of the rights occurred. So, and I would say that, so it's important to give them the opportunity as a industrial relation actors in the sector and in the enterprise that they work for. And I would say that the strategy, the tool would be collective bargaining. I would say it's important to make the collective bargaining work, and it is important to achieve the objective of the collective bargaining, which is collective bargaining agreement. Yeah. So because it's gonna address the challenges that we have identified. So basically, in the collective bargaining process, the worker and employer would have the opportunity to dialogue, to a kind of set the standard, the practical standard and doable. And then, and that's basically, in the collective bargaining agreement, you would have the issue of rights and the issue of benefits and issue of like monitoring the compliance and so on. So I think it is important to address the issue systematically through collective bargaining. I would see it as a key strategy to ensure having the remedy. And in light of that, I would update a new development in Cambodia, which I would say is a success case yet, but I would say it has a potential to address the issue in that systematic manner, basically. So, I think many of you in the room know that, the challenges that Cambodia has faced and, freedom of association, but also, low wages and so on, and supply chain issue that we talk about. And then, over the past, I would say that there has been a development, what we call a global brand supported collective bargaining in Cambodia at the moment. I think you have heard already that key sourcing companies has sign a binding agreement for the first time to support collective bargaining in the country. So it's not, so basically, kind of international structure to support local collective bargaining. So at the country level, it's not yet a sectoral collective bargaining, but a multi-factory initiative. So basically, over the past 2 years, a Cambodian trade union group, together with employer associations, have negotiated what we call collective bargaining agreement template. So that's a kind of a standard collective bargaining agreement, which employer association together with the representative national trade unions would go to the enterprise level with the assistance of the global brands to get from one enterprise by enterprise to basically to endorse and implement that collective bargaining. And in that collective bargaining agreement, there's a strong component on dispute settlement mechanism, and basically, I mean, now I would say, and link very much to our conversation today, is a kind of, I would call, supply chain, like a remediation structure. So basically, there's issue of time-consuming process to process the grievances, cases from the enterprise level. So under that CBA, it creates a bipartite structure. So employer and trade union representative, like a kind of committee, enterprise committee, to resolve grievances and disputes at the enterprise level. If it is not successfully, then it's going to be get the external mediator. In Cambodia, there's an expert organization called Arbitration Council. So it's really a council which has a very long time experience on administrating and arbitrating labor cases. So I think this has a like a kind of, because we talk about the supply chain challenges. So there's involvement of global brand in basically incentivizing enterprises which commit to the collective bargaining process and the implementation of the collective bargaining. Last, I would say that, in this exhaustive process, I would say, because we try to resolve the issue structurally, it is important to support trade union sides. Very often, I think in many countries in our region, the trade unions are represented in multiple phases. So there's a need to coordinate, to support the capacity, awareness raising, but also coordinating position of the trade union as well. So I think to achieve this process, there is a need to have a structural support for trade union group. So I think in experience from Cambodia, fortunately, I think there's a involvement of some international support organizations, in the form of raising awareness on HIEDD, among the trade unions, but also, informing them that's an opportunity for them to make use of the step by the industry. But also initiative like Action and Transformation and Collaboration, ACT, which kind of bridging between global brands and employers and trade union on the ground. And I think the last part is important to capacitate, but also to coordinate the trade union with the different streams in the country, which I think is happening in Cambodia, it happened in Indonesia, and I think it happened in other countries as well in the region. Yeah.
Thank you very much, Vesna, for highlighting also the importance of collective bargaining as part of access to remedy, because that is, of course, very specific when we deal with access to remedy in the world of work, where actually you have management and workers basically coming together when it concerns labor rights violations, which is very different from more broader human rights violations that may occur, because collective bargaining is indeed, as you say, a mechanism to deal with a number of issues in a more structural, systematic way, agreement between management and workers. And that also can include, as you say, a dispute resolution mechanism, where even if management and workers do not come to an agreement, you can seek an external mediator to get to resolution of these agreements. And that is very specific, of course, in the world of work, which you do not have the similar mechanisms outside. And collective bargaining agreements can exist, of course, at the level of the enterprise, sectoral, and of course at the national level as well. So this is also very much part of dealing with issues in a more structural and systemic way. And Valkyrie, over to you again in terms of working, of course, with labor inspectorate, labor administration. You already highlight some of the challenges, but also there is a more strategic approach, I think, to compliance in this area. Please, over to you.
Yeah, thank you. So if we're talking about the main goal of labor inspection, right, which is to achieve compliance in these work sites, right? Obviously, one of their key tools is enforcement and the other one being advice and guidance. But what I really think is going to be important for labor inspectors to actually achieve that goal is a little bit of a change in chip, right? So traditional economics would say if it costs more for me to comply than not comply, then I'm not going to comply, right? Because given that circle and that tiny red dot, I can game the system. The odds that an inspector is going to come inspect my work site are very, very small. So it's a good chance I can save some money. But if we think about it in terms of a behavioral economics approach, right? Money isn't everything to everyone. And there are often systemic reasons why it is that employers don't comply with the law. And so if we think about it in the sense, we really kind of have to take a more systemic approach to compliance. And that requires a dialogue, right, with sectors, with supply chains to really understand what are some of the systemic barriers to labor law compliance. A very simple example from Lesotho, looking at private security guards not being paid social protection contributions, right? When we really got down into why it is that that was happening consistently, we found that simply there were too many private security companies in the market driving the prices down, so they could not afford to bid at the cost of the contract, which would allow them to pay those social protection contributions. So if that's true, one option obviously is for those inspectors to try and go and sanction all those companies, which is not going to solve that systemic issue. Or another option would be create certain barriers to entry for those security providers, right? So that they have to demonstrate certain levels of training or money in escrow, et cetera. And that would reduce the number of entrants into that field and remove the systemic barrier to that labor law compliance issue. So one of the things that I would say is really important is for labor inspectorates to start working with other agencies, with employers, with workers' organizations to really understand what are some of the systemic barriers to compliance. And then in that, I would also touch on just a couple of mechanical issues. We talked about the difficulty in targeting. Labor inspectorates need to really work with other government agencies. They need to be able to share data so that they can do more effective targeting. They also, again, need to dialogue with workers' organizations and employers' organizations to really identify what are key characteristics of companies that are likely to be non-compliant, right? So that they're not wasting their limited resources visiting companies that are compliant. And then additionally, in terms of expanding that partnership and working with other agencies, and going back to sort of that behavioral economics approach, most employers find labor inspectorates to be more of a nuisance than a terror, right? Because the sanctions are so low. But they might be a little bit more concerned if a licensing authority came in, if a tax authority came in. So labor inspectorates being able to join forces with other enforcement agencies, right, that may have stronger enforcement mechanisms is also another way to kind of tap into that underlying justification as to why an employer might not be complying with the law. So I will just stop there.
So we've been dealing with quite a number of issues, I think, are an alternative dispute settlement mechanisms, enterprise level grievance mechanisms, and what is needed to make them trustful also to the workers. We've been looking at collective bargaining agreements to deal with a number of systemic issues, how to strengthen actually the connection between labor inspection and broader systems dealing with non-compliance at one hand, but also access to remedy in others. So now I would like to open the floor for questions from you. Oh, okay, I already see the hands going up. So, whoops. So first, I will try, maybe we will take a first round of questions. And if you could just introduce yourself and then say to whom you are actually addressing your question. So, sir, yeah, over to you.
Well, thank you very much for that panel. My name is Tomoya Obokata, the current UN Special Rapporteur on Contemporary Forms of Slavery. So your discussion has been very revealing. Not that then some of the things that I've seen myself by visiting countries, I mean, I encounter all these difficulties. My question is to Mr. Nguyen about the trade unions. And some of the difficulties in visiting countries like in Asia and Africa is the informal economy. And the right to organize informal workers is extremely difficult, whether they're in agriculture or particularly domestic workers hidden in economy. Are there any, my question is, I know that challenge is a challenge, but are there any good examples of being able to organize all these vulnerable workers in that particular sector? May I ask another quick question to Ms. Hansen about that labor inspection? I just wanted to kind of see other innovative ways to enhance inspection, like use of technology, satellite imagery and whatnot, and all of this technology or AI algorithms, so on, to identify perpetrators. Are there any kind of trend that you can share with the rest of the group in terms of good practice? Thank you. If you have time, thank you.
Thank you. So I saw another hand over there, please.
Hi, my name is Zuleika. I'm from Malaysia, from a financial institution. My question is to Mr. Yoon Shul Kim. I'm very amazed by the alternative mechanisms that you've shared. I have two questions regarding it. One is on accessibility and using digitalization. How do you overcome the digital barriers, especially given the diverse workforce that exists? And the second question on speed, how are you able to then increase the speed to more than 5 times of the court? And are there any challenges that you face? Thank you.
Right, so I saw more hands. Yes, please.
Hi, good morning, everyone. Adrian from North-South Initiative, Malaysia. I work with migrant workers. So the migrant worker, when it comes to remedies, they're kind of caught between the trade union, who may not be so migrant-friendly, and a whole range of third-party solutions being thrown at the supply chain. So how do we ensure that the ethics and conflict of interest in ensuring the migrant worker has in their best interest the solutions, because they're torn between these two actors? And are the trade unions really up to date about all this, the implications of these third parties? And I'm glad that you said, in the collective bargaining, they should know how these remedies are to work. But the question is also on the conflict of interest. Yeah, thanks.
So maybe one last question, because I saw other hands. Yes, please.
Yes. Good morning. My name is Priyapunisawan. I'm from Collective Union of Women Workers from Cambodia. Actually, I have been listening to a lot of discussion, especially about the collective bargaining, as well as the challenges and progress from the labor rights and human rights, and related to the due diligence as well. For my question, it's related to the representative as well as the panelists from Korea, especially about the trustworthy mechanism. So we would like you to share with all of us about the trustworthy mechanism. How can we create that trustworthy mechanism? Because we exactly need to solve problems as well as the issues that happen at the plant level as well as the national levels as well, not just only the developing country, but I think developed country as well is so important for us to use that tool for a peaceful and harmonization at workplace as well. So this is my question. Also, is this the point that we exactly need to be involved with this case as well? So please, thank you very much.
But I think that's all what we have time for, because I'm aware we only have 4 minutes left for this session. So I think I will just hand over the floor first to Vesna, and then Valkyrie, then Mr. Kim, and then finally with Cecilia, because this will be responding to your questions and at the same time some of the concluding remarks, unfortunately. So Vesna, over to you.
Yes. Well, I mean, the issue of representation, like organizing strategies, particularly in the informal economy. Yes, I think. Well, I mean, it's always a challenge to to get worker to be on board with in the trade union. So there's it has it's a time-consuming process, and it exhaustive as well. So I think classic example in Cambodia. In the garment sectors, we managed to have a very high number of union density. So basically, 60% of the industry are part of the trade union. So it's kind of like basically a success case of worker organizing. But at the same time, there has been like an increasing informal economy. So it has been difficult to organize worker in the kind of, even informal economy, even we undisclosed location. And I think that your question comes, right? Like in what way we can get these workers to be properly represented by trade union, and therefore get the benefit, get the access to the justice we talk about. And I would say that there is we don't really have the specific strategy for worker organizing. So I think trade union is an expert in organizing worker, but I just since we talk about the the CS triple D, the directive endorsed recently at the EU, and EU is like a lot of companies are subject under this law. I think it gives an opportunity to for the worker organizing as well, because under that law, that directive, basically the company are supposed to do the assessment and to do other due diligence processes, and that not just a main enterprises, but also in a lower tier of the supply chain. So the whole supply chain is supposed to be under the due diligence process. I would see it as an opportunity to improve the situation in the lower supply chain, and including the I think it probably is of the challenge of organizing workers there as well. Given it addresses it there. I think second on the issue of the representation of the migrant worker in that case, I think of course I think in very often like trade union coverage would be going to like a kind of mass like production side, so basically workers who are employed by the enterprises. I think that's the reason why in Cambodia we got this 60% union density in the garment sector, and then compared to other sectors, it would be completely different. So garment would be 60%, and then in other sectors would be 5%, even 1%, and in the migrant one it would be less than that. So I think it's a issue of representation. So if migrant workers are organized into the trade union, and that they are able to influence the agenda of the trade union, and that probably be a different scenario, I would say.
Thank you, Valkyrie.
Yeah, thank you for asking about technology. This is one of my favorite topics in the area of enforcement, and I could go on for days. I'm just going to highlight a couple of the key ones. So you would be really, really surprised to find out how many labor inspectorates around the globe do not have a basic case management system, kind of controlling all of the cases that they've done, from which they could pull basic data analytics about companies that are likely to be non-compliant. We recommend that those case management systems also start to pull in other factors. Is there a union? Is this a company that tends to use a lot of migrant labor? what their types of clients are. Do they have a lot of subcontracting? Those types of factors that also are kind of indicative of whether or not a company might be likely to be non-compliant. So that is one thing. Obviously, AI is a tool that they could build subsequently once they've got that data. But like I'm saying, many labor inspectorates simply don't even have a basic case management system with data to draw from. A second category of technology that we see a lot of, speaking of informality, is the use of satellite imagery to find out where there's agriculture that is maybe undisclosed or illegal mining that's undisclosed. The use of drones, right, to identify how many laborers, child laborers, or just workers in general that are actually on a work site that you can't necessarily access because it's hauled up from the street. That can be in construction, that can obviously be in agriculture and mining and any variety of other places, or in factories where they might be sending them out the back door, right? And a third category that I am really excited about is an example that we got from Peru, which is verify your essentially your social security or verify your subcontractors. Now, what this does is that every employer is required to report to the tax authority the entire list of their payroll. So a worker can scan a QR code, log in with their tax ID number, and see whether or not their employer has A, listed them, and B, whether or not all their social protection contributions are paid up to date. A prime contractor can also verify that all of the workers of their subcontractors are registered and up to date. And those workers, being also part of that verification process, can log in and see if they are duly registered. That then triggers labor inspections. So in the first 6 weeks of this system being put into place, Peru formalized illegally informal workers, 30,000 of them. So those are the types of data systems, right, the governments can put into place to really kind of deal with this issue of illegal informality, right? Workers that should be under the labor code that are simply not because they're not registered.
Thank you, Mr. Kim. Over to you to talk about the alternative dispute settlement mechanisms.
Thank you for the questions. I'm not good at speaking English, so I'd like to get help from an interpreter. I already explained to him. Thank you.
Oh, okay. So the first of all, for our rapid system, first I will have to explain that we have a code for it in our committee. So it's a 60 days code. So first of all, we have a rapid investigations. We get the documents from both sides. Then the documents will be composed into files and it will be sent to the LRC members. And after that, it will be given to the the committee for the final ruling. And the whole system is actually can be accessed by online as well, by video conferencing as well. And for the next question about how can we build trustworthy mechanism. So in detail, the government of the Republic of Korea redesigned the remediation system of the LLC, setting fairness, reliability, and speed. So there will be the employee members. So there will be three sectors giving the representing like ambassador, the members. So first of all, it will be the employee member representing workers. The next will be employer member representing employers. And lastly, it will be the public interest member. So this mechanism is used to make fair adjustments without being biased to one side. And in addition, the members of the pool are appointed from those recommended by the labor union, employers associations, through reasonable procedures to increase the credibility of the LLC. And I think I just missed out a little bit about the challenges that we get. It is actually about the lack of manpower because we only have 380 investigators, and another problem is budget.
Well, it's good to know at least you have 380 investigators. It's not bad, but of course, if you're dealing with 25,000 cases, it's still quite impressive. So, Cecilia, I would like to give you the floor as well for your concluding. Oh, sorry, apologies. Yes.
Sorry, I would like to make a correction. It is actually
380.
Oh,
okay.
yeah, so it is 380 investigators. Yeah.
380 investigators. Okay. So, Cecilia, for you as well, some of the concluding remarks.
Okay, thank you. So in my view, all parties, government and private sector, have a critical role in promoting and protecting human rights. However, it is not enough to just have regulation and policies to show commitment. Action from all stakeholders are needed, including the employees themselves. The government needs to enforce the regulation and provide support and easy access, especially for SMEs. The private sector need to provide clear and trusted grievances mechanism, and employee need to participate to gain access to remedies. While all these measures are important, in my view, robust prevention of human rights violation is the key. For enterprise, this means having a commitment from the top reflected in comprehensive policies that protect and respect human rights for all stakeholders. Due diligence should be conducted to identify areas that may pose human rights risks. Also, leaders within organizations should act as role model in practicing respect for human rights. Only by that, employee will feel secure and trust that they can speak up and raise any concern if they have. Thank you.
Thank you very much, Cecilia, for these concluding words. And I think very important talking about trust, talking about collaboration, and actually talking about prevention and how can actually a lot of these violations can be prevented, because this is as important, of course, as the access to remedy, but prevention, I would say, is even more important. And for that also compliance plays an important role. Collective bargaining, again, plays an important role so that you actually have the mechanisms to prevent these kind of violations and that rights holders indeed can have full access to their rights and while at the same time also enterprises, of course, can be competitive and successful enterprises. And respect for human rights is, of course, a very important component of being sustainable enterprises for the future. So I think we've come up to the end of this session. I would like to thank, together with all of you, I think our panelists, highlighting very different elements of access to remedy, as well as enhanced compliance. We could have had a longer session, I'm sure, and I apologize to all of you who still wanted to ask for questions, but we only had a 1 hour session for this topic. So thank you very much.